if so, when?
And I think recusal is very important. There's perception, and there's also the actual conflict. And I'm always cognizant of that fact. I think you have to make sure that if there's a perception that there might be a conflict of interest, then you must recuse yourself. And also with regards to actual perceptions of conflict of interest, I think you need to recuse yourself. So I would definitely recuse myself from anybody who donated to my campaign with regards to whether they're a practitioner or it's an entity, a public entity, or a corporation. I think it's very important because, again, you know, the Supreme Court is the pinnacle of the court system in our state, and so we want to make sure that people feel that their court is transparent. So therefore, you know, I would definitely make sure that I recuse myself from any and all potential conflicts that might come up with regards to this campaign or any previous campaigns as well.
Justice Cox.
So currently, as a candidate for the Illinois Supreme Court, I have a tremendous firewall between me and any individual or any contributor to my campaign. Recusal is important and is a valuable tool exercised and enjoyed by judges. I believe that anyone who contributes or is known to have contributed to my campaign, I should recuse myself so as to avoid even the appearance of impropriety. It is critically important that the citizens that we serve have trust and confidence in the decisions that we make, and that they are confident that that decision is not based upon any individual or any contributor who might have made some contribution to our particular campaign. And so I would recuse myself to the extent that I became aware of anyone who contributed to my campaign, or if I were presented with a motion, I would consider that motion seriously as to determining whether or not I should not participate in the case.
All right, thank you. Mr. Epstein.
So there's this big problem, which is that both honest people and dishonest people will tell you that they are honest, right? Promises to recuse aren't good enough. Anecdotal assurances of fairness aren't good enough. We need structural assurances of fairness. So we need to create an independent body that determines conflicts of interest and recusals. Right now, we're relying on the honor system to stop judges from deciding cases for campaign donors. The honor system has a pretty poor track record in our state. We can do better. When I was working at my law firm, I couldn't even bring in new clients unless I went through a conflicts department. It's a good policy. Our judges should have to follow it too. And it's not something that's just a hypothetical. This is stuff that has happened in our state. Sometimes judges, even if they're trying to be honest, just don't have a good sense of what is an appearance of conflict. We need another layer, an independent layer, to tell us when there is a conflict or when there is the appearance of conflict. And in the meantime, I would pre-commit to create an independent body or an independent person to determine my own conflicts until we got that set up.
Thank you. Justice House.
I'm aware of the individuals who are chairing my campaign committee, and I will not hear cases that are before me involving those individuals. However, I do maintain a firewall, so to speak, because I don't pay attention exactly to my D2 statements. I don't read them. I do know who comes to my fundraising, but I also give away free tickets so that there's some space there for people who I don't know necessarily who bought a ticket, who got a free ticket. I think that this is the system that we have is a bad system, but it's the best that we have. I would support public financing of judicial elections when our finances of the state permit, because I think that is really the best way. But right now, judges, in order to get the job, you have to be a politician. And I think we have to conduct ourselves in a way so that conflicts are not there.
Thank you. Justice Stanton McBride.
The code of conduct for all judges, and actually for candidates running for judge, is quite strict, and it requires that judges recuse themselves whenever there is an actual conflict or where there's an appearance of a conflict. I'm not going to have any trouble recusing myself in any case at any time, and if there's a conflict regarding a financial contribution, I will absolutely recuse myself. That's plain and simple. If there's a conflict in any way, a judge must automatically recuse him or herself. And if it appears that there's a conflict, the judge must also recuse him or herself. To say that the honor system has failed Well, I'm not sure what that means, but, we have obligations, and all of us as judges and candidates must absolutely follow the code of judicial conduct, and I will always do that, and I always have.
Mr. Epstein, you guys for 30 seconds.
Yeah, sure. So, I mean, 1999, a nationwide group of car owners sued State Farm Insurance, won $1 billion. That case went up to the Supreme Court. There was a vacancy and an election to fill that spot between Gordon Mogg and Lloyd Carmeier. The allegation was that State Farm funded almost all of Justice Carmeier's campaign. He wins the case, or he wins the race, joins the Supreme Court, and within months is tasked with deciding the case which State Farm is a party. The car owners petitioned the court, said, please don't let him decide this case. Our opponents just funded his campaign. And the court said, it's not up to us whether Justice Carmeier can decide the case, it's up to Justice Carmeier whether he can decide the case. And he said, I can decide the case. Cast the deciding vote in favor of State Farm to the tune of $500 million.
All right, thanks for that clarification. You should join me on the bar report if you want an election. We'll start again with Justice Cobbs this time around, and once again, you see this gentleman right over